social justice and inclusion, civic engagement, gender justice, and projects to end violence against women. In 2016, CCMW awarded Farhat the Women Who Inspire Award. Farhat is co-founder of Mothers Offering Mutual Support, MOMS, and the Ottawa Support Group for Women Who Have a Close Relative in Canada's correctional justice system. She speaks out in support of reforms to the criminal justice system. In 2018, she was awarded the Governor General's Meritorious Service Award. I'm going to pass it along to Farhat to give a few introductory words.
Good morning, everyone. Welcome. On behalf of CCMW, I welcome you all to the Knowledge Sharing Workshop. Thank you so much for registering and being here today. You will get an overview and an introduction to the larger content of the series of 7 webinars that were held earlier in June of this year, and which explore specific family law issues in detail. These will be made available to you virtually and in both official languages. In addition to the webinars, 6 brochures have been printed and produced by CCMW that also provide the same comparative information about Canadian and Muslim family laws as they pertain to women's legal rights. These are also available to you online, and if you wish to printed copies of these brochures, please indicate in the chat box, and I will do my best to deliver a set to you. The topics covered are marriage, divorce, custody and child support, family property and spousal support, domestic contracts, and inheritance. The CCMW is an equality-seeking national women's organization, and this project aims to empower Canadian Muslim women in their ability to make informed choices in the area of family law and legal rights in Canada. I just want to also add that please check out our website, ccmw.com, for our objectives and our mandate, and also for valuable resources and projects and toolkits that we have that we can all utilize to collaborate on in the coming future. Thank you very much. Agree?
Thank you very much, Farhat, for that and for all that you do for CCMW Ottawa and CCMW at large. I would like to now introduce the rest of our fellow facilitators. I'll begin with Noreen. Noreen is a lawyer and community activist. She currently works for the federal government and is part of the law practice program at Ryerson University. She is a former board member of CCMW National. Senna holds a master's in social work and a bachelor's in psychology. She has been a member of CCMW since 2008 and delivered many workshops within the Muslim communities and for community workers on the topic of violence against women of Muslim background. And lastly, we have Rabia. Rabia is a student at Carleton University studying social work with a minor in criminology and criminal justice. She has been a member of CCMW since 2016. So I'm very excited that all of them will be facilitating this workshop today. So before we do begin, I do want to go through just a little bit of housekeeping rules. I can start by introducing myself. My name is Sabrina Azrak. I'm the National Project Coordinator at CCMW. I will be your moderator for the duration of this workshop. Today's workshop is being recorded. The recording of this workshop will be available afterwards on our website at www.ccmw.com/Ottawa. We welcome you to revisit the content yourself and to share it with your network. Please do ensure that your video camera and your microphone are muted and turned off during the workshop. This will help eliminate ambient noise and increase clarity. We invite your comments and questions and will run 2 live Q&A sessions during the first half and at the end of the workshop. We will be doing this using the chat box. The chat box button is the 6th button from the left at the bottom of your screen. Once you click it, the chat box will appear on the right-hand side of your screen. If you think of a question at any point in time, just type it into the chat box and I will pose it during the Q&A portion. You could choose to ask the question anonymously by sending the message to the host, myself. The name would be CCMW staff, or you can choose to send the question publicly to everyone. An evaluation will be emailed to you later today. It will take about 5 minutes to complete. No need to write your name on the form because we want to maintain your privacy. And the information you provide will be kept confidential and private. Only authorized individuals at CCMW will have access. And lastly, if you require tech assistance, please send me a direct message using the chat box, or you can send me a text message, and I've included my phone number in the chat box already. We can now go to the next slide. Thank you very much. So the vision and mission of CCMW. The CCMW is a national nonprofit organization committed to attaining equality, equity, and empowerment for all Muslim women in Canada. Founded in 1982, the organization works to promote Muslim women's identity in the Canadian context. During the past several years, the Canadian Council of Muslim Women has undertaken initiatives to inform Muslim women, the legal profession, community service agencies, policymakers, and the general public about the differences between Muslim family laws and Canadian family laws. Previously, CCMW published Muslim and Canadian family laws, a comparative primer in both English and French, as well as a series of booklets in several languages on family law topics to further our public education efforts. Our latest project in this field is the Muslim Women's Family Law and Legal Rights Project, and in this project we update the documents and disseminate them via these knowledge-sharing workshops within different cities across Canada, particularly for Muslim women, community service providers, the legal profession, and the general public. In 2003, CCMW took the lead in establishing a coalition against religious arbitration, composed of over 50 sister organizations, including the National Association of Women in Law, METRAC, and the YWCA. The No Religious Arbitration Movement and CCMW's work represented an array of complex issues and events. We were successful in that the Government of Ontario made a decision to disallow the use of religious family laws under the Province's Arbitration Act. CCMW advocated for one set of laws to be applied to all, regardless of faith, ethnicity, race, or culture, under the existing family law legislation. CCMW believed that the use of religious laws through private arbitration to settle family matters under the Arbitration Act violated the hard-won equality rights guaranteed under the Canadian Charter of Rights and Freedoms, and has the potential of creating a two-tiered, fractured justice system. CCMW was compelled to inform Muslim women and about their choices that they have available to them within Muslim and Canadian family laws, and simultaneously educate individuals and institutions that assist them or work with them to resolve family disputes. CCMW is composed of a national board that works to further CCMW's objectives at a national level, as well as 15 local chapters made up of members whose passion and hard work advance the vision of CCMW within local communities. To learn more, please visit us at www.ccmw.ca. Next slide, please. So I'm now going to pass it on to our facilitators who will begin this workshop.
Good morning, everybody. My name is Rabia, and I'll be starting with the topic of marriage, so let's jump right into it. For some people, marriage is an important part of formalizing their intimate or romantic relationship with another person. How people get married will be different depending on their respective cultural background and traditions. Some will want a simple ceremony witnessed by close family and friends, followed by some kind of small celebration. Others want a big party or celebration so they can celebrate their union with many other people. Some want a civil ceremony, others want a religious one. Most people who get married want to incorporate at least some elements of their family culture into the event. Next slide, please. So what is marriage? For Muslims, marriage is a significant and highly regarded aspect of both social and religious life. Marriage in the Quran, otherwise called a nikah, is understood as a union between a man and a woman. The foundation and most important principle of this union is peaceful companionship and tranquility. So the primary purpose of marriage for Muslims is the maintenance of a relationship that is built on courtesy and sympathy. In classical Muslim law, marriage is understood as a civil contract between the bride and groom. So the contract is formed like any other contract through an exchange of offer and acceptance between the two parties. The contract of marriage was also understood by classical jurists as a social institution of tremendous importance, with far-reaching effects on such socially critical issues as procreation, lineage, inheritance, and the preservation of social harmony. The exchange of offer and acceptance, the main condition of marriage, can be done orally by the bride and groom. They are designated legal representatives or guardians, otherwise known as a wali. It is important to note that there are differing opinions among jurists, different schools of thought within classical Muslim law about the legal guardian being a requirement for marriage. But for the purposes of this workshop, we will not go into that. A written contract is not strictly necessary in the classical tradition. Besides mutual consent, the contract of marriage has two other important conditions. There must be a dower, otherwise known as a mahar, representing a gift to the bride, and the marriage cannot be secret. A secret marriage in Muslim law is considered null and void. In Canada, the federal government, through the Prohibited Marriage Act, Prohibited Degrees Act, federal legislation, regulates who can marry whom. The administration of marriage, which is how the ceremonies happen, falls within the jurisdiction of provincial governments. This means that each province can set its own rules for how marriages take place. But there are many similarities from one province to another. In Ontario, the relevant legislation is the Marriage Act. Next slide, please. So who can get married? Next slide, please. We talked about that. Thank you. So who can get married under Muslim law? Under Muslim laws in general, any two Muslims of opposite gender can get married if there are no obstacles to their marriage and if they meet the formal requirements for a valid marriage contract. In classical doctrine, Muslim men are allowed to marry a Christian or Jewish woman, otherwise known in the Quran as people of the book. A Muslim woman cannot marry a non-Muslim man due to the strict requirement of Muslim men as husbands to be a legal guardian, which is to bear the financial responsibility to his family. Traditional doctrine rejects marriage between a Muslim and an unbeliever. And I'd like to put an asterisk that there are differing opinions, and the debate is ongoing about whether a Muslim woman can marry a non-Muslim, but for the purposes of this workshop, we will not get into that. In the classical tradition, scholars required a certain degree of compatibility between the bride and groom. This typically meant an equivalence in social, cultural, and financial status. This requirement has generally been left out of modern laws of Muslim states, given the difficulty of determining compatibility in a modern, urban, interconnected world. Still, many religious scholars today will view compatibility in a sense of proximity and values as a desirable feature in marriage. Next slide, please. So looking at married under Canadian law, any two unmarried adults may marry with few restrictions as outlined. Any individual who has previously been married can remarry in Ontario if the previous marriage has been dissolved in a manner recognized under provincial law. And since 2005, same-sex marriages are legal. Next, please. So who cannot marry? In Muslim law, there are three main reasons for which marriage between two people may be prohibited. If the people are related through blood or marriage, or if the woman is breastfeeding. Blood relatives whom a man may not marry are specifically outlined in the Quran, and they are as follows: the mother and all female ancestors, the daughter and all female descendants, sisters and half-sisters, aunts of either side, and nieces. A man cannot marry because of other marriage relations include mothers-in-law, daughters-in-law, stepmothers, and stepsisters. A man is also prohibited from marrying two sisters or a woman and her aunt simultaneously. In Canadian law, according to Canada's Marriage Act, a person cannot marry someone to whom they are related by blood or adoption. For example, full or half siblings, adopted siblings cannot marry. Parent-child and grandparent-grandchild marriage is also illegal. In Canada, marriage between first cousins is generally socially taboo, but not illegal in most of North America. A person can only be married to one person at a time. So nobody can marry somebody who is married to anybody else. And as I said before, same-sex marriage is legal. Next slide, please. So the minimum age for marriage. Under traditional Muslim laws, there's no formal age limitations on when the contract can be formed. Most classical scholars grant fathers the right to promise their minor children under 9. This right is specific to the father alone. No other guardian is allowed to promise a minor in marriage unless a minor specifically empowers them to do so. Consummation of marriage cannot take place until the child has reached puberty and are physically and mentally prepared for a responsibility of a family. But most countries where Muslim personal status laws applied have introduced a minimum age, which is agreed upon as being 18. Next slide, please. In Canada, the marriageable age is set by provincial and territorial legislation. Canada's criminal code makes it an offense for anybody under the age of 16 to marry anyone, and for anyone who assists in carrying out a marriage. So a person who marries anyone under age can be charged. Otherwise, age limits are set by provinces and territories. Under Ontario's Marriage Act, any two people who are at least 18 years of age may marry. If either party is between 16 and 18, they have to get the consent of both sets of the parents. While regulations on the legal marrying age may vary from one jurisdiction to another, most are similar to Ontario's rules. Next slide, please. So who can perform a marriage in Muslim law? So marriage is a contract, and however, there are no formal or ceremonial requirements, and this offer and acceptance can be done orally. For the contract to have any impact in Canada, the marriage must be registered with Canadian provincial authorities, which is important for the recognition of legal rights under Canadian law. In Canada, many but not all imams or recognized leaders are authorized by Canadian law to register the marriages they solemnize. Alternatively, a couple can go through a separate civil ceremony in addition to the religious one to register the marriages. All traditional Muslim scholars agree that the marriage cannot be secret, so any marriage that's secret is void. Most Sunni scholars view the presence of two morally upright Muslim witnesses as a formal requirement. Some say that while it's not necessary to have a witness to a marriage contract, it is still recommended. Others agree with the majority that the presence of witnesses is a formal requirement. There are a lot of ways to interpret Islamic law pertaining to marriage. Next slide, please. So under Canadian law, marriage in Ontario, in most other provinces, can be solemnized by either a civil or religious ceremony. In a civil marriage, the parties purchase a license from the municipal clerk, and the solemnization is performed by a judge, a justice of the peace, or any other person. Okay, so next slide. Oh, sorry. Under classical Muslim family law, no person should be married against their will. There are different requirements under different schools of law for how marriage can be concluded through a guardian, but none allow the guardian to marry somebody against their will. The general rule is that the consent of both parties must be given in clear terms, at which point the guardian cannot withhold their consent unless they have good reason. Canadian law does not require guardianship except for people between 16 and 18, as we mentioned before, in which case the consent of both sets of parents is required. Next slide, please. So the types of marriage. Sunni schools of Muslim law are unanimous in prohibiting temporary marriage, but in the Shia school of thought, they do allow temporary marriages. Marriages in Canada must be registered in court by way of a civil or religious ceremony. Couples in common law unions can contract to set out their rights and responsibilities through a cohabitation agreement. And as we mentioned, same-sex marriage has been legal in Canada since 2005. Next slide, please. So bigamy and polygamy. Traditional Muslim doctrine grants men the right to marry up to 4 women simultaneously according to the Quran. Women can only marry 1 man at a time. The Quran establishes conditions on polygamy to ensure fair treatment of all wives. So these conditions include that he must have the financial ability to provide for all the wives and is obligated to care for them equally, and both financially and in time spent together and in affection. And if he cannot, then he is recommended to only marry 1 woman. So both bigamy, which is going through a marriage while married to another person, that's what bigamy is defined as, and polygamy are prohibited under Canadian criminal law. Anyone who enters into such a marriage, and anyone who assists or celebrates or is a party to this marriage is liable to a maximum penalty of 5 years imprisonment if they are found guilty. And moving on, the legal status of the subsequent wife in a polygamous marriage is ambiguous. If she entered into the marriage knowingly, then her marriage is valid only under religious law and she has no rights under civil law. However, she may have some rights if she can prove that she is unaware of her husband's existing marriage. If she entered into a polygamous marriage in a country where it is legal, she may have some rights under provincial family laws in Canada. Generally, though, women who consent to a polygamous marriage on the basis of religious or cultural beliefs are in a very vulnerable position under Canadian law. Next slide, please. Next slide. Rights and duties in marriage. There are basic rights that follow from the conclusion of a valid marriage contract in Islam. As we saw, dower is due to the bride by the groom. Technically, dower is considered a condition of the validity of the marriage rather than a duty under the contract, although often payment is part of the dower is deferred. Classical Muslim scholars agree that the husband or guardian must support his wife financially, including providing a suitable place to live, sustenance, and clothing. The husband also provides for the children. The degree of financial support and exact amounts vary according to the husband's means and what the wife has been accustomed to prior to the marriage. Some classical scholars also believe that a husband must provide domestic help to his wife upon request if she is not used to performing chores, for example, if he can afford it. The wife's primary obligation under the marriage contract is to live with the husband and provide companionship. Any other alleged obligations are subject to this agreement. For the purposes of this workshop, we won't go into detail about what these can be. The classical jurors view that the distinct obligations for each spouse is reciprocal and interdependent. If a wife leaves indefinitely, so if she leaves the marriage, the husband is entitled to suspend financial support. It is important to know that withholding sexual intercourse is not considered disobedience under the classical doctrine. In Canada, marriage contracts are made under provincial and territorial legislation and can include any number of stipulations defining rights and duties. There are certain matters that cannot be dealt with under marriage contract, and they would be unenforceable if they were. Anything relating to children, for example, cannot be stipulated in a marriage contract because they are made on an assessment of the best interests of the child at the time. In most cases, a marriage contract cannot limit a spouse's right to matrimonial home. Moreover, provisions that make the rights of a party dependent upon remaining chaste are unenforceable. So that means cheating, in other words. It is important that women seek independent legal advice before signing a marriage contract. Even if conditions of the agreement are unfair, once it has been signed, the courts cannot usually intervene and set it aside. Under Canadian law, physical and sexual abuse of any kind within the marriage is illegal and can lead to criminal charges. So that is the conclusion of marriage. Thank you.
Assalamualaikum everyone, this is Sana Khalil and I'll be speaking to you about custody and child support. So under traditional Muslim law,
it's distinguished between guardianship of the children and custody or care of a dependent child. So under Muslim law, the father has the right of guardianship over children from the time of their birth, but custody or the right to live and look after minor children who cannot care for themselves belongs to the mother. The age and conditions of such custody vary, but the principle remains the same. It's important to note that in Canada, disputes over custody will be exclusively decided based on Canadian family law, which uses the best interest of the child test to make all decisions. Even when parents make their own arrangements for the children under Muslim law, courts can refuse to enforce them if they are found not to be in the best interest of the child. Okay, and the Divorce Act is federal, and the provincial and territorial laws in Ontario is the Children's Law Reform Act, and court judgments provide a set of rules, formal and informal, for deciding custody matters. These rules provide significant direction, but also leave room for discretion on the part of the court. So parents can decide on custody arrangements in a separation agreement, but the courts can disregard if it's not in the best interest of the child. So people have many reasons for choosing either the Divorce Act, which is federal, or the legislation in their province or territory to resolve custody and access disputes. So unmarried people must use the provincial and territorial legislation because they're not married, and of course the Divorce Act is just for married people. However, some married people prefer to use the provincial territorial legislation if they're not immediately seeking a divorce, or if they cannot afford the cost of applying for divorce, or if the provincial territorial legislation offers them better custody and access options. Anyone trying to decide which legislation is more appropriate should seek legal counsel, legal advice from a lawyer specializing under family law. So under Muslim law, the father has guardianship over their children as well as the responsibility to provide for them financially. The mother is granted custody of all her minor children. The father's responsibility to provide for maintenance, which is financial support, to his children continues whether or not the children live with him. This responsibility includes all necessary living expenses as well as education, and guardianship also entails legal representation of minor children. Okay? The guiding principle throughout these doctrines is the best interest of the child. So this is something that the Canadian law and Muslim law have in common. The underlying assumption is that a mother is most capable of caring for her minor children, whereas a father is responsible for their financial support. So under the federal and provincial territorial legislation, the custody of children in Canada is determined using the best interest of the child test. Will consider the following factors: the child's needs and circumstances, the child's view and preferences, and the older the child, the more his preferences will be taken into account. The ability and willingness of those applying for custody to provide the child with guidance, education, and necessities of life, including, for example, support for any special needs. The ability of each person applying for custody to act as a parent and provide a stable family environment, and we will also look at the relationship to the child of the person applying for custody. So the Divorce Act only applies to people who are married and seeking a divorce, also addresses the care of children after their parents separate. Parenting orders assign parenting time as well as decision-making responsibility. Both time with the children and decision-making about them can be shared or can rest primarily with one parent. The court makes its decisions about parenting arrangements using the best interest of the child test, and it's based, like I mentioned, on many factors to be considered. So many of the same of these factors are in the provincial legislation, such as the Ontario Children's Law Reform Act. The federal legislation explicitly sets out a requirement for the court to consider family violence as part of the best interest of the child test. It provides a detailed and extensive definition of family violence. Courts may use a family assessment to assist in determining the best interest of the child. So they're usually completed by child psychologists or social workers who spend time with the children in the presence of each parent separately. So regardless of who has primary responsibility for the children, both parents have the right to information about health, education, and the welfare of their child. So this means that a parent who does not have primary care or decision-making responsibility but has some contact with the child can ask questions and be given answers about counseling, school report cards and activities, healthcare, and other such matters, whether or not the custodial parent consents. Okay. So we go back to Muslim law. So most Muslim jurists agree the mother should have custody until age 9 for girls and age 7 for boys, but some scholars extend it to the age of puberty for boys and marriage for girls. Classical jurists tend to believe that girls needed to stay in the care of their mothers or longer than boys. According to most classical schools, a mother will lose custody to the father if she remarries. Okay, so if she gets remarried, she will no longer have the custody of her children. If both mother and father are incapable of caring for the children, the parents will go to the paternal grandmother. If the paternal grandmother cannot care, then the paternal aunt. If the paternal aunt cannot care for the children, then the maternal grandmother. And if the maternal grandmother cannot, then the maternal aunt. A mother cannot move the children to a land or far away from their father's town unless she's returning to her hometown. The same applies to the father. He cannot move the children away from the mother's town. Custody and guardianship rights in Muslim law are non-negotiable since they exist to protect the children's rights, not the parents' rights. Thus, in a settlement, the mother, she cannot surrender her custodial rights to the father or vice versa, because it's always considered to be in the best interest of the child to be in contact with both parents. Now, under Canadian law, provincial territorial laws, care and decision-making for children is the equal responsibility of both parents until they enter into an agreement or there's a court order that says something different. This means neither parent can unilaterally take the children and withhold them from the other. Time spent by a parent with a child is determined based on what is best for the child and is not a legal right of either parent. Parenting arrangements can be agreed on by both parties in a separation agreement or through mediation. So, separation agreement or mediation. However, if what the parents agree is not in the best interest of the child, the courts can disregard the agreement. The court can order the parent to share physical care and decision-making for the children, or can give those responsibilities primarily to one parent, while setting up time the children spend with the other parent. Okay? In some situations where there are concerns for the child's well-being, or that the parent may not return the child, that time spent with that parent may be supervised. If there are concerns for the safety of the primary parent because of abuse by the other parent, the exchanges of the children may be supervised. The exchanges means, for example, if the father was abusive to the mother, she might drop off the kids to her ex-spouse's parents' house half an hour before he will come to pick them up, so they're not in contact. Or they could have the exchange done in public if she fears for her safety. Parenting orders can only be changed if there has been significant change in the circumstances of the family. So most custody orders made in one province will be enforced by other province, as long as they're in the best interest of the child. There are legal and financial consequences for parents who do not follow a parenting order. Police may become involved to find and return the children. Orders can also stipulate the condition under which a parent can take children outside Ontario or Canada. And also, if a parent moves to another province, the agreement will still apply in the other province, in Canada. So, international custody. In spite of the mother's unquestionable right to custody of minors under Muslim law, many modern Muslim majority states have laws that favor the father as a result of a misguided expansion of the concept of guardianship. Furthermore, with minor exceptions such as Turkey, most Muslim-majority countries did not adopt international legal instruments that allow international cooperation to return children to their habitual residence in the case of illegal abduction by the other parent. Habitual residence is where the child usually resides. Therefore, if a father takes his children to his Muslim-majority home country without the mother's knowledge, it will be difficult, although not entirely impossible, to use that Muslim country's legal system to regain custody over the children. So Canada is one of the 84 countries to have signed the Hague Convention on the civil aspects of international child abduction. This treaty is the only multilateral agreement providing assistance in cross-border abduction. And the objective of these conventions are to deter child abduction, promote cooperation among countries and their respective authorities, and ensure the prompt return of abducted children to their home countries. Okay? So if a child is removed illegally from Canada to another country that has signed the Hague Convention, the parent in Canada must contact the central authority here in Canada, which is either the Federal Minister of Justice or the Attorney General of the province or territory where the child was living at the time they were removed. The parent will bring a case for enforcement in the country to which the child has been taken or from which the child is not being returned. If a child is brought to Canada illegally from a country that has signed the Hague Convention, the case for the child to be returned to that country would be brought in Canada. In these situations, the court is not making a determination of what is the child's best interest or of which parent should have the responsibility of the child. The court's job is to determine whether the parent seeking the return of the child had what is called custodial rights. If so, if the parent was exercising those rights then, subject to some exceptions, the child will be returned to where they were living before they were removed. And this is often called a habitual residence. Okay, they will be returned to their habitual residence based on if the parent had custodial rights. Okay, once that has happened, if there is not a parenting order already in place, the court in that jurisdiction can proceed to make one based on what is in the best interest of the child. The main exception to returning a child is if the parent who has removed the child can establish that there is a serious risk of harm to the child if the child was returned. And this could include serious family violence. Now, child support. Under Muslim law, child support is the father's absolute responsibility, regardless of where or with whom the children live. Support should cover all necessities, including education, and should increase proportionally to the father's financial abilities. In case of the father's inability to provide for the children, the mother may coerce payments through a court order or request a loan guaranteed by the father's assets. In Canada, both parents are expected to contribute financially to the support of their children. In most situations, child support is the money paid by the parent who does not have primary responsibility for the children to the parent who does. The amount of support to be paid is based on the income of the person paying child support and the number of children. Child support is calculated slightly differently when the children spend roughly equal amounts of time with each parent, or in situations where some children live with one parent and some live with the other. A court can change the amount of child support if there is a significant change in the circumstances of either party. For example, the parent paying support loses their jobs or gets a significant pay rise, then the payment will increase or decrease accordingly. Or extraordinary expenses, for example, needs or activities of the child that involve costs above those covered by a child support order. Okay? Or undue hardship, although undue hardship is almost never recognized by the court. So generally, child support is paid until the child reaches the age of 18. Support may end earlier if the child is no longer under parental control, has married, or has had a child of their own. Support may continue past the age of 18 if the child remains enrolled full-time in school or is disabled and unable to become self-sufficient. Child support payments are not tax deductible for the payer and do not constitute taxable income to the recipient. The provinces and territories have child support enforcement mechanisms to ensure that people with child support responsibilities meet them. In Ontario, orders are registered with the Family Responsibility Office, which collects the money from the payer and pays it to the recipient. When the payer is in arrears, the Family Responsibility Office has the authority to garnish paychecks and bank accounts, seize GST, and income tax returns, or suspend the payer's driver's license, professional license, or even passport. All the provinces, territories have reciprocal enforcement agreements with one another that allows enforcement of child support orders, even if the person paying support moves from the place where the order was obtained to a different province or territory. Finally, child protection. While not directly related to the breakdown of a marriage, child protection issues do arise from time to time in this context, especially when there has been violence in the family. These issues are governed by provincial territorial legislation. In Ontario, it is the Child, Youth and Family Services Act that ensures the safety of children in their family. The Act approves agencies to operate as children-based societies and protect children under 18 years of age. It used to be 16 in Ontario, but they increased it to 18. When the society has concerns, it can investigate, provide guidance, counseling, and other services to families, supervise children, and in extreme cases. And in extreme cases, it's always a last resort. They will remove children from their parents and provide care for them in another setting. So we will continue with spousal support, family property. All right. Hi again, everybody. All right. So let's introduce spousal support and family property. Traditional Muslim family law does not recognize joint property or joint finances for married people. Next slide, please. Each spouse retains their own separate patrimony, property they have inherited. In other words, before, during, and after marriage. The family home, which is provided by the husband, remains his property unless it belonged to the wife prior to marriage, or was explicitly gifted to her by her husband, thus leading to the transfer of ownership. Okay? So financial support of the wife and children is the husband's obligation. It is the primary obligation that follows the marriage contract by force of law without the need of any specific provision in the contract. Classical Muslim scholars have long debated the circumstances under which an obligation may be suspended, but generally the conditions remain very limited and are rare exceptions to the general rule. So moving on to Canadian law. Next slide, please. Marriage is seen as a partnership, with each person making roughly equal, even if substantially different contributions. For example, if one spouse works outside the home and the other works at home raising children and running the household, these two contributions are deemed to be equal. Each spouse is to benefit equally from the two sets of contributions. This principle underlies Canadian family laws with respect to the division of property, which are dealt with via provincial and territorial laws. In Ontario, it is the Family Law Act that sets out how property is divided, but the general approach is similar across provinces, all provinces and territories. Because marriage is viewed as a partnership, both people have a legal right to an equal share of the property that was accumulated during the marriage, whether or not they contributed financially. Okay, in other words, even if one spouse has not contributed money to the purchase of, for example, RSPs or cars or the home, they still have a right to an equal share of the value of any of that property that was acquired during the marriage. For those wishing to use a different regime, division of property can be dealt with by way of a domestic contract, which Sana will be speaking about in the next segment. So spousal support is the money paid by one spouse to the other for that person's support after the marriage has ended. For the purpose of spousal support, spouses are defined as people who are married to each other or who have lived together continuously for at least 3 years or who have a child together. Enforcement of child support payments is given priority over spousal support payments. Because marriage is seen as a partnership under Canadian law, there are no legal provisions requiring one spouse to support the other while they are married. It is assumed that both spouses will ensure the financial needs of the other and are taken care of while the relationship is intact. Next slide, please. So under Muslim law, marriage does not result in the joining of property or finances. It's because marriage was not seen as a union between financial equals. Under classical doctrine, the man was the sole and absolute provider for the family. Marriage was seen as an arrangement in which the woman would relocate from her father's home to her husband's home in exchange for a dower and full financial support. So the man's house, along with everything he has acquired for it, remains his, even if such properties are used jointly by the spouses. Okay? While this arrangement deprives the woman of any rights and property acquired for the family by the husband, she gains by retaining full rights to her own property and property including her dowry, gifts from the husband or her family, her inheritance, and any returns on investment, rent, or other income. The husband has no right to any portion of her wealth under the principle of division of legal patrimony according to Muslim law. The issue of separate ownership of family property is often addressed through the inclusion of a carefully drawn-out condition in modern marriage contracts. For example, the bride will require the transfer of the family home to her ownership as part of the dower or the future modification of dower to account for inflation, for example. So next slide. Property under Canadian law. The basic principle underlying the division of family property is that marriage is a partnership and that all property accumulated during that partnership should be shared equally between the partners, aka spouses, regardless of who actually paid for it or in whose name it is registered. This is called equalization of net family property. There are certain exceptions to this principle. Property acquired before marriage, property acquired by gift or inheritance from a third party, proceeds of a life insurance policy, or property that the spouses have specified ownership of in a domestic contract. Perhaps most importantly, the matrimonial home is treated differently. So the full value of the matrimonial home is to be shared equally between the spouses, even if the home was bought by one spouse prior to marriage. For example, if I own my house fully and there's no mortgage on it, then I marry my spouse and my spouse moves into the home with me, this becomes a matrimonial home. If we separate some years later, I have to share the full value of the home equally with him, even though he has made no financial contribution to its value. Where spouses are unable to agree on the equalization of the family property, the court can order that one spouse pay the other an amount that would result in the equalization between them. So specifically in Ontario, legislation governs the division of property in some polygamous marriages. A woman who is part of a polygamous marriage, if that marriage took place in another country where it was legal and recognizes polygamy, it can rely on Ontario law with respect to the division of family property when that marriage ends, if she is an Ontario resident. So next slide. The matrimonial home is, under Muslim law, she does not have a legal claim to a matrimonial home, including its financial value, unless it belonged to her before marriage. So there are no formal rules about the division of property, but it is discussed without any consensus, though. Opinions are varying, from the woman getting all the household goods to getting only the quote-unquote the clothes on her back, essentially getting what she brought into the marriage. Under Canadian law, the matrimonial home is a place where the spouses ordinarily lived together during their relationship. Only married people can have a matrimonial home. There can be more than one. For example, if a married couple in Ontario has a house in the city and a house in a cottage where they go to spend time, they're both considered matrimonial homes for the purposes of property division. Both spouses have an equal right to live in the matrimonial home unless one has received a family court order for exclusive possession of it. So possession in knowing affects ownership or the right to include the matrimonial home in the calculation for the purpose of equalization. In other words, if the wife has an order for exclusive possession of the home, that means she and the children can live in the home if she has children, and the husband cannot come onto the property. However, he continues to have a financial interest in half of the value of the house. She could buy him out, or they could sell the home and split the proceeds. Okay, so next slide, please. Spousal support under Muslim law. So under Muslim law, the husband owes his wife two main obligations: the dower, which is the mahar, as we discussed earlier, and maintenance, which is due throughout the marriage. So everybody in Islamic scholarship agrees that a wife is entitled to full support and maintenance covering her livelihood, clothing, and in some cases, domestic help, as long as she continues to reside in the marital home. Some scholars have argued that a wife who abandons her home is still entitled to support, but that's besides the main point, which is she is entitled to support during the marriage. Classical scholars disagreed when it is due, the payment, but generally it is the moment the marriage begins. So the payment of spousal support was seen by most scholars as the husband's most fundamental obligation. Refusal to pay had to be justified by neglect or any other marital obligations by the wife. Since living in the marital home is the wife's most basic obligation, deserting the husband was a main situation in which payment of support could be justifiably suspended. So this is important because if there's a misconception that a wife must be obedient to deserve her financial support. This usually follows from a misunderstanding of the concept of disobedience as a lack of submission to the husband's wishes. That is far from the truth. What most classical jurists meant by disobedience was not unquestioning submission, but rather abandonment of the home altogether. So it is deeply held assumption in Muslim law that marital relations should be based on reciprocal understanding rather than obedience of one spouse to another. So generally, spousal support is only paid when the marriage is still intact. Upon divorce, the obligation usually comes to an end. There are some details regarding, pregnant women and receiving support, etc. But many modern interpreters argue about this situation. And ultimately, there's no consensus amongst Muslim schools of law on the amount of spousal support. Some jurists take the position that the amount cannot be specified by law. Others argue that the amount of support can be calculated based on husband's wealth and income, and the higher the income, the higher the amount of support. All can agree, though, that basic elements of support besides the home, a husband is responsible for her daily essentials, food, clothing, needs, basically everything that you need to pay for, he is responsible for. Anything that can be defined as a necessity. Okay, so spousal support under Canadian law. Next slide. Under Canadian law, both the Divorce Act and provincial territorial laws in Ontario, aka the Family Law Act, set out objectives for spousal support. There are to recognize economic advantages or disadvantages arising from the relationship or its breakdown, equally divide between the parties any financial consequences arising from the care of children, relieve economic hardship arising from the breakdown of the relationship, and promote the economic self-sufficiency of each partner within a reasonable period of time. People in long-term conjugal relationships, otherwise known as common law, I guess, even if they were not married, may qualify or be required to pay spousal support if the above criteria are met. Whether spousal support is to be paid, how much it should be, and for how long it will be paid is very dependent on the circumstances of the relationship. So, for example, in a long-term marriage where the woman remain at home to care for children and raise them, spousal support will be ordered for a long period of time, or even permanently, at a high level, depending on the income of the husband. It is not uncommon for spousal support payments to be made until the recipient spouse remarries. So in a short-term marriage in which neither party's ability to earn an income has been negatively affected, so both people have a job and they're both earning an income, there could be no spousal support. Where one spouse, typically the woman, has left the workforce to raise young children, requires a period of time to reestablish herself in the workforce, there may be a short-term spousal support order for gradually decreasing the support over time. When determining the amount of spousal support to be paid, the courts will take a number of factors into consideration, including the length of the cohabitation and the functions performed by each partner during that time. For example, child rearing versus earning an income. So if someone stays home to raise the children and the other spouse is making all the money. So the agreements entered into by the partners, so for example, the marriage or cohabitation agreement, the parties' current and likely future assets and needs, the dependent partner's capacity to contribute to their own support, and the ages and physical and mental health of the parties. So the federal government has established spousal support guidelines to standardize the amount of spousal support awarded to a certain degree. Usually a spousal support agreement or order will specify that support will stop on remarriage. So spousal support is tax deductible for the payer and declared as taxable income by the recipient. Spousal support orders are enforced using the same mechanism in place to enforce child support. So in Ontario, that means the Family Responsibility Office. People in both married and common law relationships can use a domestic contract, which Sana will be talking about shortly, to set up their own approach to spousal support as well as other issues related to their relationship. So that summarizes spousal support. Thank you.
Hello everyone, we're going to continue with domestic contracts.
Sana, I believe that there's some questions that we wanted to address before you continue.
Okay.
That's great. With questions.
Okay, thank you all for your patience during this time. So we do have a couple questions that we want to get through. The first question reads, I know a nikah was brought up as the way that Muslims get married. Do you also have to legally get married as well, or can we just do the nikah?
Oh, Noreen's mic is not on, and I believe she's trying to answer the question.
Okay. Thank you for that, Rabia. I will try to answer some of the questions that have come up, and of course, Rabia and Sana, having presented, will jump in at any time. So if I understand the question, it says, do you also have to get legally married or just do the nikah? So if you're looking to have a marriage recognized religiously, the nikah is the only requirement. If you're looking to have it recognized in Canadian law, that nikah needs to be registered, and it will be recognized as a civil marriage. So I'm not sure if that answers your question, but to be recognized as married religiously, you require the nikah only.
Thank you very much, Noreen. I'm going to continue on with some questions. The second question reads, adoption was mentioned as a type of marriage you can't have in Canadian law. Is this the same in Muslim law as well?
So Muslim Islamic Sharia principles are three. It is, I'll just bring that up for you. I want to make it clear. You cannot marry someone you are related to by blood, by marriage, and by breastfeeding. So if there are children that are not biologically related but are adopted and have been breastfed by the same mother, they may not be biologically related, but they've been breastfed. So under the Muslim concept, they would be considered siblings and therefore would not be able to marry each other, if that is your question.
Thank you very much, Noreen. The third question is, why would the mother lose custody of the child or children if she makes the decision to remarry?
So I saw there were a few responses to that particular comment on the chat. From the research perspective, just to answer that question, the Islamic perspective is that the guardianship or the responsibility, if you will, legally, financially falls to the father. So the word guardianship, father. So it follows the father according to the doctrine. The mother could have custody and be taking care of the child, physically nurturing, be in the same physical house, but it's the guardianship element that is basically assigned by default to the father, given the structure historically of how Islam is practiced in Islamic countries. Now, it would vary from country to country, even Muslim countries, and as well, I mean, the overall governing issue is the best interest of the child. And sometimes in certain situations, leaving the guardianship with the father is in the best interest because he's the one providing financial support, right? So it's a very case-specific, case-by-case situation, and also it would vary between which jurisdiction you're looking at, which could be, Tunisia might be different than Pakistan, which might be different, and then there may be splintering. So in this research, the idea was just simply to highlight the fact that generally in Islamic law, it would follow the responsibility towards the father. And I defer to whoever made the response to on the chat. I'm not sure. I can't speak to that comment about the majority of Muslim scholars. That would, in my opinion, would be more of a practice issue that might be modernized as jurisprudence evolves.
Thank you kindly, Noreen. The second last question is, the majority of Muslim scholars say if the mother gets remarried, the custody rights move to her mother. There is only one opinion that says custody moves to the father, but it is weak and discarded. In general, women have the custody rights. Did anyone have anything to add to that, or can we leave that comment as is?
Only to say, again, it's just the default structure, but everything normally is evaluated according to the best interest of the child. And that has many factors.
Great, thank you. And the very last question is, what is the reason or rationale behind the interpretation?
Sorry, just hopping on real quick to maybe ask the person who's asking the question to clarify. Is there a specific, are they referring to a specific subject that we discussed? Or just general, does this mean general Islamic interpretation?
I see that the comment, I think, came after the question came after the comment about the custody passing to the maternal grandmother, and now I see that in the chat that the person saying the question is already answered.
Okay, great. That is all for the questions for this part. We're going to continue to ask questions, and then we'll answer them at the end of this workshop.
Okay, so we're going to continue with domestic contracts. So in Muslim doctrine, marriage is a contract entered into by the bride and the groom, sometimes through their guardians. A domestic contract that regulates some aspects of marriage in Muslim law may include conditions as an addition to the contract. Okay? So the fundamental guiding principle in Muslim law is that any contractual conditions mutually agreed upon between the parties are valid, provided that such conditions are not in violation of clear divine injunctions and do not defeat the purpose of the contract itself. Which meaning do not defeat the purpose of marriage. Okay? All the classical schools have agreed that the bride, and less frequently the groom, and her guardian are entitled to include some conditions in the marriage contract. There is some disagreement as to the degree to which the husband is bound by such conditions, which conditions are valid or invalid, and the consequences of including an invalid condition in the contract. Some scholars have held that conditions included in the marriage contract that are not otherwise invalid are obligatory upon the husband, but some say that respecting these conditions is only recommended, and others have said that husbands are under no obligation to satisfy any conditions other than that follow from the marriage relationship by force of law, such as the financial support. Because most Muslim majority states have now adopted modern legal systems in which mutually agreed contracts are binding, valid conditions included in the marriage contract will be enforceable in those legal systems. In Canada, can I go to the next slide? Okay. In Canada, provincial and territorial legislation governs what kind of private contracts individuals can make to set their own terms for their relationship or for the end of the relationship. In Ontario, cohabitation agreements, marriage contracts, and separation agreements are all considered domestic contracts and are governed by the Family Law Act, FLA. Domestic contracts can cover many aspects of a couple's relationship, but most focus on financial and property matters. Okay, that's for the Canadian law. Okay, so validity of domestic contracts under Muslim law. Traditional scholars divided the issue in a marriage contract into three categories with respect to their validity. Those that are valid, those that are invalid but do not invalidate the marriage, and those that invalidate the marriage. There is some disagreement among different schools about what makes a contract valid. Some schools accept the validity as long as the subject and a contract do not defeat the purpose of marriage and hold that those conditions are binding on the husband. Others tend to believe that only topics intrinsic to the contract of marriage need to be followed and no other topics need to be included. Conditions that are commonly seen as valid include the woman's right to work, financial support for her continued studies, the right to remain in her own town or country, and to live in a household of her own. So these are valid conditions that can be added to the marriage contract. Many scholars have also accepted as valid a clause setting out the wife's right to demand that her husband do not take another wife, and that the clause also stipulates that marriage contract will be dissolved if he does so, if he remarries. Many have also validated clauses that provide a certain amount of time after the marriage ceremony before sexual relations can begin. Clauses that are commonly seen as invalid without invalidating the marriage contract are ones that are either illegal or incompatible with the purpose of marriage, such as conditions to withhold sex indefinitely or to divorce an existing wife, or for the wife to live away from her husband's residence. Clauses that invalidate the marriage altogether include term limits making the marriage temporary. So you cannot have a clause in the marriage saying that the marriage is temporary and will end at that date, for example. And also that any marriage that involves the intention of getting divorced. A husband can also include clauses in a marriage contract, but they cannot in any way contradict his basic obligations to support his wife and children financially. Therefore, clauses that attempt to shift the financial burden from man to the woman are invalid. Okay, now, validity of domestic contracts under Canadian law. Not everything can be addressed in a domestic contract. Ontario's Family Law Act, like legislation in other jurisdictions in Canada, specifically excludes post-separation parenting from being governed by way of marriage or cohabitation. This is because you cannot make those decisions. They have to be made based on the best interest of the child. And you cannot anticipate at the beginning of a marriage when children are not probably even born. A separation agreement, on the other hand, which is another form of domestic contract, could set out the parenting arrangements for the children because it's being written after the parents have separated, at which time the best interest of the children can be determined. Ontario law also states that any provision in a marriage contract limiting a spouse's right to the matrimonial home is unenforceable. More generally, courts can disregard any provisions that are not in the best interest of the child, are unreasonable with respect to child support, make the rights of a party depending on remaining chaste, or preventing a remarriage of either party. So these clauses are not acceptable. Also, upon application, a court may set aside a domestic contract or part of the contract if either party failed to disclose significant assets, debts, and liabilities. If a party did not understand the nature or consequences of the contract, or if the contract is not in accordance with the law. To be valid, a domestic contract must include a certificate or waiver of independent legal advice to ensure that the person understands the contract and is not signing under coercion. Also, for example, if you have a newcomer woman and she's presented with this domestic contract and she doesn't speak English, she could later take this to the court and, say that she didn't understand the content, she doesn't speak the language. Since domestic contracts allow people to sign away their legal rights, it's important that both people seek independent legal advice before signing a marriage contract or cohabitation or separation agreement. So the husband and wife shouldn't have, for example, the same lawyer. They should have each their independent lawyer and legal advice. Even if terms in the agreement are unfair, once it has been signed, the court cannot intervene and set it aside unless the other person did not provide full financial disclosure or the contract was signed under duress, coercion. Like all matters related to Muslim contracts under a modern state, the authority to enforce the contract will depend either on the parties, a designated arbitrator, or the state within which the parties live, if the contract follows the rules and forms required by such state. In the absence of a centralized Muslim authority, it's up to the parties to identify a competent person or authority to assist in managing any disagreement that arises. Alternatively, the parties should ensure that their domestic contract meets legal requirements to be enforceable in the jurisdiction where it has been written. To be enforceable in Ontario, a domestic contract, whether that is a marriage contract, cohabitation, or separation agreement, if in Ontario, it must meet the requirements set out in the Family Law Act. The same is true in other provinces and territories. So provincial and territorial legislation also sets out domestic contracts made outside that jurisdiction are to be handled under the laws of that jurisdiction. In Ontario, a domestic contract is valid regardless of where it was made as long as it is in accordance with Ontario law. The contracts that were signed outside Canada would be valid if it's not contradicting the Ontario law. But it shouldn't be unreasonable. So enforceability under Muslim law. To ensure enforceability of a Muslim domestic contract, it should be drawn upon according to the terms set out in family laws of the province or territory where it's been written. Anyone preparing a domestic contract should work with a lawyer who is knowledgeable about family law in their province or territory to ensure it meets all the required elements. A Muslim woman entering into a domestic contract should keep in mind that Muslim laws widely invalidate any condition that gives away a woman's natural rights under a marriage contract. Such natural rights include her right to full financial support by her husband, the right to her dower, and her own financial independence, the right to travel to see her family, and the right to perform religious duties. So she cannot sign away those rights, in a contract under Muslim law. None of those rights can be surrendered by the wife from a standpoint of a Muslim law. Now, enforceability under Canadian law. Either party can approach the court to enforce a domestic contract. To be enforceable, a domestic contract must conform to the requirements contained in the relevant provincial or territorial legislation. In most cases, this means there must have been full financial disclosure by both parties. The contract must be in writing, signed and witnessed, and must not have been signed under coercion or duress. While not mandatory in all Canadian jurisdictions, it's strongly recommended that both parties obtain independent legal advice before signing the contract. Even if a component in the contract is unfair, with the exception of certain invalid conditions mentioned above, the courts are bound to uphold the contract unless the above form and process requirements have not been met. Courts generally give deference to domestic contracts, taking the position that competent adults should be free to set the terms of their own relationship and only intervene in extreme circumstances to set it aside. The Supreme Court of Canada has ruled that adults are free to sign away their legal rights and must assume responsibility when they do so, even if the consequences prove to be negative. So all the courts are bound by this decision. So be careful what you sign. This principle does not necessarily reflect the interests of vulnerable people. For example, a woman with abusive husbands, women who are newcomers to Canada and are unaware of their legal rights here, or women who are coerced by their communities into signing a private agreement without the benefit of proper legal information and advice. So Canadian courts will enforce a mahar if it has been properly prepared and meets the standards of any other domestic contract, according to the relevant, provincial, territorial legislation. Generally, it must be in writing, signed by the parties and witnessed. Okay? In writing, signed by both parties and witnessed. Full financial disclosure must be provided by each party to the other, and there must be no duress or coercion. The more specific and detailed about the amount, timing, and circumstances in which the mahar is to be provided, the better. So, you need to, as much as possible, include the amount, the timing, and circumstances in which the mahar will be given. In Canada, the mahar does not replace spousal or child support and does not form part of the family's property. So that, it cannot replace these things. It's something extra. We will now move on to divorce. Rabia?
Thank you, Sana. Hi again, everybody. Okay, so last topic. I think it's the last topic. Next slide, please. So because marriage in Islam is considered a contract, as we've mentioned several times, like any contract, it can be dissolved. There is no strict equivalent to a civil divorce. In legal terms, it's called repudiation in traditional doctrine. But there are a number of ways in which marriage can be terminated. The most obvious route is through talaq, which is the right to unilateral divorce that is granted to the husband. Although classical Muslim law grants the man the right to end the marriage without any reason, such repudiation is considered reprehensible, and classical doctrine placed several procedural and financial hurdles to make sure it would be used as narrowly as possible. So for a marriage conducted according to Canadian or Muslim law, none of the Muslim methods of dissolution will be recognized by Canadian law as a valid divorce. Under Canadian law, next slide please, if two people are legally married to one another, either of them can apply for a divorce to end their marriage and resolve related issues such as custody and support. Unless a marriage is properly registered with the state, it is not possible to get a divorce. A woman in a polygamous relationship whose marriage is not registered cannot get a civil divorce, as she is not married under civil law. So how divorce happens under Muslim law? As mentioned earlier, divorce is a right given by a husband, by Muslim law to the husband. The husband may divorce his wife at any time without the need to give a reason. And however, only men of sound mind who have reached the age of maturity may perform this right. Divorce by a minor or someone who is mentally incapacitated is considered ineffective. So ultimately, divorce can happen without the wife being present, but she must be informed of it immediately. In general, no witnesses are required for the divorce to be effective, although many scholars hold that to be a condition. Okay? So most jurists also invalidated divorce by an intoxicated man, since intoxication makes it doubtful that the words were uttered unintentionally and as a result of a sound mind. However, some people believe that even when the husband is intoxicated, the divorce is valid. So this is clearly going into detail here about what is considered valid or invalid, but it's nonetheless important. Muslim law does cover these details. But ultimately, the utterance of divorce has to be expressed by the husband in a clear and unequivocal terms in order to be effective. So given the seriousness of the matter, the language needs to clearly reflect the intention to end the marriage. So this repudiation or divorce must occur when the wife is not menstruating. The husband makes an unequivocal oral expression of his intention to end the marriage. So after this expression is uttered, the wife should remain in her husband's home for a waiting period consisting of 3 menstrual cycles. And it is outlined in the Quran that the husband is basically chastised not to kick the wife out of the marital home, even if they are divorced, because they have to go through this waiting period. So even if the divorce utterance occurs during menstruation, even though it is technically valid and not proper, a minority argue that the husband may be ordered to revoke such a repudiation. So even a proper and standard divorce is revocable in the sense that the married couple may simply resume marital relations, and therefore the marriage would resume. However, only 3 revocable repudiations, so that's the utterance of the word talaq in Muslim law, so 3 of them may be effected in one marriage, following which the dissolution of marriage becomes final. So if it is uttered 3 times, then the divorce is becomes final. So it can get very tricky and complicated, as you can probably tell. It also becomes final if the waiting period elapses without the resumption of marital relations. So once the dissolution is final, the couple may not resume marital relations. If they do, this would be considered to be adultery. The marriage may not be resumed once again unless the former wife marries another man, consummates that marriage, and then separates from him. So in other words, if there is a divorce or utterances in Islamic law and they wish to get back together, the wife or the woman has to marry another man, consummate that marriage, and then separate from that man in order to get back to the original husband. So marrying another man for the sole purpose of being allowed to return to the former husband, as I just explained, is illegal and reprehensible under Muslim law. So besides the standard form of divorce or repudiation mentioned above, or mentioned earlier, many Sunni schools recognize this non-standard triple repudiation. So it's important for people to understand that there is a difference in Sunni jurisprudence and Shia jurisprudence, respectively. So, like I said, Sunni schools recognize a non-standard triple repudiation. A husband repudiates, so he says the triple talaq to his wife 3 times at once. Shia scholars, however, dismiss the validity of this practice, and even within Sunni schools, it is highly discouraged. When this takes place, the marriage is instantly and irrevocably dissolved. So a man may repudiate his wife in person or through proxy. This ability to grant somebody else the authority to repudiate a marriage on behalf of someone else may be used by a woman to terminate her own marriage through delegation from the husband. This is a valid and common arrangement, and according to many schools, is irreversible. So once a woman is delegated the right to dissolve the marriage on her husband's behalf, she can exercise that right at any time. Besides the waiting period, revocability of repudiation or divorce or talaq, and the irrevocability of a final dissolution, classical jurists have also designed the law in such a way as to make repudiation potentially financially disastrous for the husband. So upon repudiation, the husband must pay all of the delayed dower immediately, and has to continue to provide child support and in certain cases spousal support for up to 2 years. So other ways in which a Muslim marriage contract can end include a wife-initiated proceeding for which she does have the right in Muslim law, in which she requests a dissolution for the marriage in exchange for releasing the man of his obligation to pay the delayed dower and other possible monetary concessions, however. This is considered a negotiated type of dissolution in the classical doctrine. So moving on to, next slide please, Canadian law and how divorce happens in Canadian law. Divorce cannot be dealt with by way of domestic contract or private agreement, nor can it be arbitrated. So they have to go through the legal procedures outlined in the Federal Divorce Act. So until that happens, the marriage is not over, and the couple is still considered married under Canadian law. It is important to note, especially for people working with people who do not have citizenship status, that you do not have to be a Canadian citizen for the marriage. For the marriage does not have to have taken place in Canada for them to get divorced in Canada. Okay, so to start a divorce in Ontario, at least one of them has to have lived in Ontario for the 12 months preceding the divorce application, so for at least a year. And similar to residency requirements in other provinces and territories. So meaning the same requirement for a year or 12 months consecutive residence in other provinces, it applies as well. So if both people live outside Canada in another country that does not recognize Canadian marriage, they may be able to obtain a divorce under the Civil Marriage Act. So in order for either party to remarry under Canadian law, the couple has to be legally divorced. So both the husband and wife have the right to initiate a divorce, whether or not the other party approves. The Divorce Act requires lawyers to discuss the possibility of reconciliation with their clients and inform them of services that might assist them in reconciling with their spouses, unless the circumstances of the case are of such a nature that it would clearly not be appropriate. So according to case law, reconciliation needs not to be discussed in situations of an extremely lengthy separation. So like abandonment, for example, a well-established subsequent relationship, children from a subsequent relationship, or mental and physical cruelty. Lawyers are also required to discuss with clients the advisability of negotiating matters that might be subject to support or custody order. Lawyers must provide a statement certifying that they have had such discussions with their client as part of their divorce application. Okay, so the court is meant to satisfy itself as that reconciliation is not possible. If any stage in the divorce proceeding, the court believes there is a possibility of reconciliation, it will adjourn proceeding the divorce and give the spouses an opportunity to reconcile. So ultimately, a divorce will not be granted until the court has satisfied that a reasonable child support arrangements have been made. So the court can also withhold granting a divorce in cases where an applicant is involved in subverting the administration of justice through suppressing or fabricating evidence. We won't go into that. So moving on to grounds for divorce under Muslim law. Next slide. So besides the unilateral right or delegated repudiation and negotiated dissolution, traditional law also recognizes the woman's right to request a judicial termination or a divorce of the contract, also referred to as separation. Unlike the man's right to end the marriage by repudiation, a request for judicial separation can only be granted if the woman is able to provide grounds for the dissolution of marriage. So it's showing that the husband has failed to fulfill his basic marital obligations, for example, so providing financially for her and her children. So judicial separation can also be demanded by the wife if her husband has been missing for 6 months or more. Some people say 4 months or more, or some scholars, or if he has not made himself sexually available for 4 months. So sexual satisfaction or sexual availability. Besides disappearance or fundamental failure to fulfill marital obligations, most schools of jurisprudence in Muslim law do not allow separation for a wide variety of reasons. So this can be because traditional judges see themselves as mediators, and there are different, schools of thought regarding the right for wives to file for separation. But it is important to note that in a certain school, there is the right to file for separation for harm, such as in the case of domestic violence. And another ground for judicial separation for the Maliki School, which was a school that does recognize the right of the wife to file for domestic violence, is discord. So basically a deep and irreversible disharmony between the married couple. So anyway, many modern Muslim states have incorporated mechanisms for judicial dissolution of marriage that take into account different forms of abuse and irreparable disharmony. So moving on to grounds for divorce under Canadian law. Next slide. The Divorce Act allows for one ground for divorce, so marriage breakdown. A marriage breaks down when the couple has been living separate and apart for at least 1 year. Either spouse has committed adultery, or one spouse has treated the other with such physical or mental cruelty that it is no longer possible for them to live as husband and wife. So for living separate and apart for at least 1 year, for this to be valid, the spouses must have been living separate for 1 year immediately prior to the divorce proceedings and should still be doing so when the proceedings end. So when the separation must be physical. The couple can be considered to be physically separated even if they continue to live in the same house. Okay, so there also needs to be a recognition that the marriage is over, even if that comes from only one of the spouses. So the end of sexual intercourse is not a conclusive factor in determining whether the couple is living separate and apart, but it is nonetheless taken into consideration. Other factors to be considered are whether the spouses continue to communicate, so if they socialize, if they're seen by other people who know them as a couple, whether they have separated their financial obligations and responsibilities, and how they share responsibility for the children. So during the 1 year of living apart, couples undergoing an attempt to reconcile, they can resume living together for up to 90 days without interrupting the calculation of the 1 year time requirement. So this is getting into details. So the next reason or the next ground is adultery. So this means where one spouse commits adultery, the other spouse may use this with proof as grounds for divorce. The spouse committing adultery cannot use it as the ground, only the other spouse. So the one accusing the other one of adultery has to use that as the ground. If the adultery happened many years before and was known to the other spouse, who continued with the relationship regardless, it will be difficult to have adultery accepted as the basis of a divorce. Okay, so physical and mental cruelty for divorce applications to succeed on this ground, both cruelty and its intolerability has to be established. If a spouse was mentally or physically abusive to the other spouse before they married and continued that abuse after marriage, it will be difficult, according to lawyers, to use this ground because of the requirement that the cruelty be intolerable and to continued cohabitation. So where the grounds for divorce are either adultery or cruelty, there is no requirement that the parties live separate and apart for 1 year. So next slide, please. After a divorce under Muslim law, upon ordinary repudiation, the former husband must continue to provide for his wife through the waiting period. Once the dissolution is final, the man must immediately pay all of the delayed dowry, or the mahr, which can amount to a significant sum. So the former husband must continue to provide child support and may also be required to pay spousal support for a limited time period. Since there is no concept of family property in Islam, property belonging to the wife remains hers and property belonging to the husband remains his. Division of property and other payments between the former spouses are an important part of the divorce. And there are documents and the webinars that are on the website. We'll continue to go into this in detail. So after divorce under Canadian law, next slide, The value of property acquired over the course of marriage, as well as the full value of the matrimonial home, even if it was bought before the marriage, is to be shared equally between the spouses upon the marriage breakdown, regardless of whose name is in it or who pays for it. When determining the amount of spousal support, the courts consider factors such as the length of the marriage, functions performed within a family unit by both partners, any agreements entered into by the partners, current and likely future assets, the dependent partner's capacity to contribute on their own support, and the parties' ages and physical and mental health. So parenting arrangements for children as well as financial support for them must also be worked out between the parties, either as part of the divorce proceeding or separately. Many people choose to use provincial or territorial laws to resolve all of these issues. So that means property division, child and spousal support, and parenting arrangements, and then applies for a divorce simply to formally terminate the marriage. Restraining orders also, should that be necessary, must also be dealt with through provincial territorial law. There are no provisions in the Divorce Act about that. Once people are divorced, they are free to remarry other people, and there is usually a waiting period around 31 days for the time the final order is issued by the court. So jurisdiction, as with all matters of Muslim family law, it is important for people to carefully consider jurisdictions will recognize their marriage and what laws apply to them. If a marriage is performed according to the laws of a modern Muslim majority state or country, it must be ended according to the laws of the same state. Informal arrangements through religious figures, either in performing or dissolving a marriage, may not be recognized under state laws if the proper process is not followed. Divorces granted outside Canada are recognized by Canadian courts. However, if a couple has been married under Canadian law and later divorces according to religious law, their divorce will not be valid and they would still be viewed as married under the civil law of Canada, which would mean they could not enter into another marriage or another civil marriage. And that concludes the divorce portion of the workshop.
Okay, I was wondering if we could go to the questions and answer questions to any period and come back to the inheritance.
Certainly.
Great. So I'll read out a couple of the questions that we've received. So the first question reads, I understand that under Ontario laws, both parents contribute financially. There is no obligation that the father provides for his wife and children. At divorce, assets are divided equally. Is that correct?
There are a few things in that sentence. So the first sentence, that under Ontario law, both parents contribute financially. If you're talking about the divorce, that both parents contribute financially, or are you talking about marriage, during the marriage? So I'm gonna go with the divorce aspect. And your final comment on that sentence says, at divorce, assets are divided equally. So the idea is, regardless of what you contribute during the marriage, okay, at the time of divorce, the prevailing formula is a split of 50-50 for most common assets. Okay, so if you have a vehicle, or you have, what is understood to be the matrimonial home, or you have a pension plan, things like that, according to each specific asset, would be divided 50-50, regardless if one person contributed 20% or 0%, or it was contributed 50-50 throughout the marriage. So there's a lot of historical reason behind that, but the prevailing understanding is because it was very easy for, in previous times, for women who were not permitted in the workplace, who did not earn salary, to then be divorced and left destitute. So these laws originally were enacted to protect women from being left financially destitute after a marriage. Now, things are a little bit different today where women are either equally earning or earning more. Every scenario is different, but the rule is such that regardless of what you contribute, at the end of the marriage, it would be looked at primarily from a 50-50, and it would be adjusted according to circumstances. So if there was a prenuptial agreement before you signed the marriage contract that said, my house that I'm bringing into the marriage is mine, and you're relinquishing your right to claim it if there's a divorce, that is a valid pre-marriage agreement. So the 50-50 would apply, but then we would look, was there an agreement pre-marriage that wasn't illegal that the court could then recognize? So you see, it's a general rule, but then again, it would depend on individual circumstances. And the middle sentence of that comment that says there's no obligation that the father provides for his wife and children, I'm not sure I understand the context of what that means. If you mean that at divorce, a father would not be required to pay alimony to their separated spouse or child support, then that is not actually correct. It would again depend on the circumstances.
Thank you very much, Maureen. Our other question is, can a Muslim woman live according to Islamic law? For example, withhold her money and not contribute anything, and then at divorce she gets half of her husband's assets?
So I think I covered most of that in the previous answer, but I understand the concept from my perspective as a conflict of laws, right? So if you identify as Muslim and want to follow the spirit of Islam, or you want to follow the Sharia element, which is, according to the research, the man would have the guardianship role, the legal responsibility, the financial responsibility to care for his female spouse. Again, we're talking Sharia, and then the children. Does that mean the woman would not contribute or is not obligated? That's the general reading that people would look at when they look at Sharia. Is that what practically happens? Is that the arrangement between a husband and wife? That's a separate issue. But on paper, that's the general understanding. The obligation is towards the father, the husband, and then the financial requirement isn't imposed on the woman according to the Sharia general traditional script. Let's put it that way. So at the end, if there's no financial contribution during the marriage from the woman and there's a divorce, is she entitled to 50%? In Canadian law, yes. Because the idea is she contributed to the household in non-monetary ways that may not be, $50,000 a year in salary, but housekeeping, food, children, child rearing, whatever the domestic duties, depending on that arrangement, they should not be devalued because they do not come with a official pecuniary amount attached to that role as part of the family. So it's a larger discussion, but in general, I'd have to say that statement is correct. How it's applied is another issue. I don't see any other questions, so I'm going to let time to the next topic.
Okay, so we're going to continue with our last topic, inheritance. So we start with the Muslim law. So Muslim laws of inheritance are among the few areas that are addressed in a lot of detail in the Quran. And one of the striking features of Muslim inheritance regime is the limited rule of bequest. So bequest is the property that you give in a will. And this is limited to 1/3 of the deceased estate. Okay, following the payment of all debts, including delayed dower and funeral expenses. Okay. So after the payment of debts and bequest, the estate is divided in shares of 1/2, 1/4, 1/8, 2/3, and 1/3, and 1/6 among a group of specific blood and marriage relatives following detailed Quranic injunctions. So in general, males will receive double the inheritance of females who are in the same category. Okay. So in Canada, the manner in which people can determine what happens to their property and belongings after they die is governed by provincial law. In Ontario, that's primarily the Succession Law Reform Act. So individuals are free to leave instructions via a will to have their property disposed in any way they wish. And when one spouse dies and leaves a will, the surviving spouse has the right to take the property as specified in the will or to receive their entitlement under the Family Law Act. Okay. So the female half-share rule. The female half-share rule is established in the Quran, which contains an unequivocal injunction making it difficult to reverse in Muslim law. However, parents of daughters have found many ways to increase their daughters' shares, either through bequest or through a will, like 1/3 of their property, or through establishment of a trust with the daughters as beneficiaries. Another option is to divide a portion of the parents' property among the children while they're still alive. The half-share rule only applies to males and females in the same category, for example, sisters in relation to brothers. So the rule does not mean that a daughter will inherit half of what an uncle or grandfather, for example. There are many explanations of the half-share rule. Some of them are historical, like historically men were the primary breadwinners and providers for their family, so it was assumed that the money they get will be spent on the family, on the wife and the kids. But it's no longer necessarily the case. Remember that these laws were developed 1400 years ago. Others argue that many other things the Quran was attempting to reach an ideal of gender equality in a gradual manner. Since in the 7th century, like pre-Muslim Arabia, women did not inherit at all. So to say that they would inherit half was a big deal. It was progressive. In all cases, it's understood that the Muslim inheritance system is deeply rooted in a reformist attitude towards the tribal practices that were predominant before Islam. So the practices that were predominant before Islam were like withholding inheritance from the daughters, distant relatives, and generally the more vulnerable. Okay, so the intricate system of inheritance was designed to ensure that those who control the estate do not get to dispose of it as they please in an arbitrary manner. So, in modern Muslim majority states, most continue to apply the female half-share rule, although some, like Tunisia, have begun to adopt an egalitarian regime. There is no equivalent to the female half-share rule in Canada. People can dispose of their assets however they wish through a will. In other words, if someone chooses to do so, their will could stipulate that their daughters receive less than their son, or that their sons receive less than their daughters. So, who may not inherit in Islam? So non-Muslims do not receive inheritance in Islam. The same goes for stepchildren. Since Muslim law does not recognize adoption, and any children that are cared for by the deceased who are not biological descendants can only inherit through bequest. So if let's say I have adopted a child and I'm living in a Muslim country, I would write in my will, the will can maximum include like 1/3 of my estate that I'm giving this or that property to the adopted child, because the 2/3 of the property will be divided among blood relatives. Under Canadian law, anyone may be specified in a will to inherit or all or in part of the individual's property. So under Canadian law, I could give all my estate to a stranger that I met like 5 days ago. Since adoption is legal under Canadian law, adopted children are considered as dependents and can also inherit. Okay? Nor is there any legal distinction between children born inside and outside marriage in the Canadian law. So, validity of the will. Under Muslim law, a will is not required, but is valid within the limits of 1/3 of the estate. That is, the value of the estate addressed in the will cannot come to more than 1/3 of the estate. Okay? Under Canadian law, for a will to be valid, it must be in writing and be signed by 2 witnesses. The exception to the rule is a will written entirely by the testator. Testator is the person who writes his will in their own handwriting. So this is called a holograph will. So the testator, the person writing their will, writes the will in their own hand and dates it. So there are no witnesses required. So anyone challenging this will have to prove that this is not the testator's handwriting. A will is revoked if the testator gets married or divorced, writes a new will, or gives written instruction to revoke the will. So if you get married or divorced, your will is no longer valid. You need a new will. International wills are considered by Canada if they are properly executed, which means they're in writing and they're witnessed. So challenging a will under Canadian law, challenging a will is very difficult. It's a lengthy process and it can be ultimately unsuccessful unless there is considerable and compelling evidence. If a person is successful in challenging a will, most, if not all of the legal costs will come out of the estate. Even if the person is unsuccessful, if their case is not unreasonable, they may be able to claim at least some of the legal costs through the estate. Okay, so what if someone dies without a will under Canadian law? So this is called dying intestate. And in those situations, it's dealt under the provincial territorial law. So in Ontario, it would be the Succession Law Reform Act. That's the legislation that governs these situations. In other jurisdictions, the legislation sets out the consequence by which various people can inherit when someone has died intestate. A person who wants to make a claim in that situation must start a court process to set out a ground for their claim, and the rules for that are set out in the Ontario Succession Law Reform. If there is a spouse, that person gets most of the estate, followed by dependents, children. Dependent children definition is under 18 or over 18 if they're disabled. Followed by other children in this marriage or previous marriage or outside the marriage, or usually adopted children. Followed by parents, then siblings, then grandchildren, and so on. When there's no will, it's a mess, and anybody, whether it's the spouse, the dependent children, or more distant relatives who want to share in the estate, have to get a lawyer and go to court. So in Ontario, the first $200,000 of the estate goes to the surviving spouse. Okay. If there is one child, the remaining amount is divided equally between the spouse and the child. Okay, and if there are 2 children, then the spouse gets, for example, the first $200K, and the remaining amount, the spouse will get 1/3 of that remaining amount, and the 2/3 of the amount will be divided equally between the children. So that's in the case of 2 children. Okay, and if the value of the estate is less than $200,000, the spouse gets the entire amount. Now, we will continue with power of attorney. So people pick their family members or friends as power of attorney. It's important to pick someone you trust. It's a good idea to pick at least one person who's younger than you, because there's a chance they will be living longer than you. Many people pick their partner and an adult child, or their partner and somebody they trust who's younger, so that if their partner dies, the power of attorney stays in effect. The power of attorney for personal care, so there are 2 powers of attorney, personal care and property. So we start with personal care. So this gives the attorney the authority to make healthcare, housing, and other decisions related to the person's personal life, if that person is mentally incapable of making those decisions. Healthcare decisions include such things as consenting or not consenting to treatment. Healthcare decisions do not include medically assisted dying. So if I have the power of attorney for an aging parent, that power of attorney can stipulate that I have the authority to say no to treatment if my parent is not competent to make that decision of their own. But I cannot use that power to say that my parent wants medically assisted death. No. The power of attorney for property gives the attorney the authority to make decisions related to the person's financial affairs when that person is not able to do so. So for the power of attorney for personal care to come into effect, the person has to be mentally incapable. Okay? You have dementia, mental delay, or you had a stroke and you don't have the mental capacity to make the decision for your health. The power of attorney for property, though, it can be used for convenience. Let's say I have to travel outside Canada for a year, but I need certain decisions to be made about investments that I have. I can write a power of attorney to give that power to my adult child, my spouse, or a close friend. It can be, I can be perfectly competent, but simply I'm unavailable because I'm, let's say, outside the country. Or it could be that I'm unwell and not able to attend to my financial affairs for a period of time. Okay, or I could be permanently incapable because of dementia, for example. Okay, so power of attorney ceases to have any legal effect as soon as the person dies. So power of attorney is for when the person is alive, and will only have legal effect once the person has died. Okay, so very important to remember. A power of attorney grants a lot of power to another person. It's important to be sure that this is someone who's worthy of the trust that's being given to them. While it's possible and legal for someone to prepare their own power of attorney, for example, the government of Ontario has an excellent power of attorney kit online. It's still a really good idea to get legal advice before you analyze the power of attorney. Thank you. So we'll continue with any question related to inheritance or any other topic.
Thank you, Sana, for that. I don't see any other questions. I do see a comment by Shaheen, a few of them. Did anyone want to respond to Shaheen, or do you want to continue on?
Yeah, I'm done for the topic. Noreen, are you able to answer this question about inheritance? So Shaheen is saying that bequesting is done while you're alive. Yes, you can do this while you're alive as well. You can dispose of your property while you're alive. For example, if you feel that it's unfair for your daughter to get half of the share of the brother, you could give her some inheritance while you're still alive.
So I'm just reading the comments. So while you're alive, you can dispose of your assets however you want. Okay? The idea is upon your death, whatever is remaining of your assets and your death, the will govern how whatever is remaining will be disposed of. So one of the things I've seen in documents, and sometimes it goes without being contested, and other times it will be contested. If, for example, a parent leaves for their child, female daughter, a certain amount that is not equivalent to the prescribed Sharia fraction, so they give more while they're alive, and then say, upon my death, this daughter will not receive anything because I gave it while I'm alive, that's okay. That's okay to do, but it may be contested after the death if there's no proof or that kind of understanding. So you can request what you like during your time here in any way, shape, or form to dispose of your assets. The idea of having a will, or if you don't have a will, then the law will come in and divide it according to Canadian law, not Sharia law, to Canadian law. If you don't have a will, that's something that happens because you're no longer able to do it yourself. Does that answer your question? I see something here about...
Thank you, Noreen.
Yeah, okay, pretty much, okay. Because I see something here about the half rule is based on males are the providers of Islam. Yeah, so again, it goes back to the comments about divorce and marriage and financial contribution. We are Muslims trying to live according to the spirit of the law. Most of us, some choose to observe Sharia and the principles more strictly. Others choose to defer to Canadian law, and if there's a conflict, that's when the court would get involved and decide according to, you know, the structure. Is it okay that someone wants to divide their property this way, and why? So that's a larger issue. I think the idea of this workshop was to just give the outline of what is in both laws, what is written, how it's applied, gets applied on a case-by-case basis.
Thank you, Noreen. So, is that it on your end, Sana, Rabia, and the rest of the facilitators?
Yes, we're done with it. I wondered if anyone had any questions related to immigration that didn't come up in this workshop.
So while people are considering maybe sharing some questions or comments, I do want to say thank you to everyone who participated in this workshop. And just a reminder that you will receive a link to an evaluation and to please fill it out, because that is how we learn to better our workshops and do better next time. I'm going to pass it to Farhat to give the final thank you. And Farhat, the floor is yours.
Thank you very much for to the presenters. You did a great job. I know it's long and wants to hold your attention, but you did a very good job. Thank you very much, and thank you, Noreen, for your expert advice. I'm sure there are among the participants who have knowledge of the laws and are associated with the legal community. So your feedback is most welcome, and of course, all the material is available online as well. If you have any special requests, and like I said, the copies of the printed booklet. If you have clients you wish to give it to them, please let me know, and I will make an attempt to drop them off. Thank you very much, everyone, for joining. Thank you. Thank you, Sabrine, for your excellent moderation, and again, thank you to the facilitator.
Yes, a final thank you to Noreen, to Sana, to Rabia, and to Farhat for this excellent workshop, and thank you to each of the participants for joining in. Have a great Sunday, everybody.
Thank you, everyone. Thank you, Sabrine.